I think we can start, Rahul.
We can start, Dheeraj. It's fine.
Thanks. Okay. So I welcome everyone to this webinar series started by Corporate Responsibility Watch in collaboration with Workers Solidarity Network and School for Management and Labor Studies, TIS Mumbai. And to begin with, I would like to invite Dr. Amita Joseph from Business and Community Foundation to introduce today's webinar. Amita, please. Amita, you have to unmute yourself. Sir.
Yeah, is that okay? Can you hear me now?
Yes.
Yes. Yeah. Okay. So thank you, Dheeraj, for inviting me, and welcome to all the panelists who will be speaking today on the debasement of labor rights and the precarity in time of COVID-19 and the need for promoting decent work if that is at all possible. I wish we had more workers here, and I hope in a sense, we are all workers, but the actual shop floor, perhaps some of them in that group of 70 MSP could be amongst those whom we are speaking about. We know that the economy was already in the doldrums much before COVID came into the picture. We also know from the CRW analysis of the top 500 companies that we have been doing for the past 4 years that there has been a growth in contractual labor, a decline in formal employment, a decline, of course, in women's employment as well and people with disabilities, and undermining of labor unions, garment sector, electronics. We know from the Safe in India study, Sandeep Sachdeva and the Ajivika Bureau and others, of the dire strait of the supply chains, particularly in the whole auto sector in the NCR region, where young workers are losing limbs, lives, lack of training, lack of any occupational safety standards. And we know that this engulfs the entire sector, we also know that the ESIC, as we know it, is underprepared. And of course, the tragic migration of workers, I think, made us all weep in the absence of housing, contracts, wages. So we are all aware that existing laws cover only 11 million out of the 450 million workers. And we know that some of these are the impacts of chasing that ease of business index, or presently, as we are trying to do to outdo China as a new factory hub, we are aspiring, to a new low. So in the interim, in this very period, we saw the LG gas leak in Visakhapatnam, which saw a tragic loss of lives. And they say that this is attributed to the lack of assessment of trained workers. So, what lessons have we learned from Bhopal or any of our industrial accidents? I think it was Azim Premji who said that the interests of business and workers are aligned, and particularly today, more than ever before, and that labor laws are hardly among industry's top constraints. It's an unstable tax structure, it's a weak contract enforcing environment, the absence of skilled workforce that they attribute to being industry's real constraints. So what is it that prompted states like UP, MP, Gujarat, Madhya Pradesh to attempt labor reforms, which is neither well thought of nor relevant? Labor laws, we know, it comes under the concurrent subject, cannot be sidelined by state ordinances passed through the back door, as was done in Uttar Pradesh. The problem, we know, is both process and timing. And using a livelihoods versus lives debate, is a false choice, as Mr. Premji correctly put it. And it's not the right framing of issues. So using a pandemic to already push through labor exploitation is questionable. And I'm glad there is so much of focus on it, including on May 22nd, the labor unions for one of the first times came together to take this up as an issue. Diluting weak laws. We know that enforcement of labor laws is weak in this country, just as the enforcement of environmental laws is a weak subject. So diluting laws are not the way to boost economic growth and activity. It will only pitch workers and business against each other. So we need, in fact, it's because it's pandemic, we will need better sanitation facilities, we'll need better health insurance, we'll need better training for workers at the workplace. In fact, the opposite is what needs to be done and will be required in times to come. But we know that the government very hastily also withdrew very quickly, its order on the payment of wages during lockdown. So what are we up against? We are up against, not a very pro-worker environment. And we also know that states are outdoing, trying to compete with each other and, the race to the bottom, as it were. So I now leave it to the panelists to tell us in detail as to, their analysis of the situation, which is both, distressing, unfortunate, and a matter of concern for us all, across the country. And I'm glad that there's so much of focus today on this issue in this webinar and otherwise, the front pages, even of business newspapers like the Mint and the Business Standard are talking about this. So over to you all, and I'll come in much later. Thank you.
Thanks, Amita. Without taking much time, I would just give some logistical clarification. So we will keep participants on mute during this webinar, and because with so many people, it's very difficult to manage if any audio disturbs the or others' speech and all. Also, logistically, you can put your questions in the chat box, and once all four of the panelists complete their speech, we can take those questions, and Rahul will be moderating that part. Just to begin, today we have four esteemed speakers with us. We have Professor K.R. Shyamasundar from XLRI Jamshedpur with us. Then we have Sabina Devan, who is the President and Executive Director, Just Jobs Network, with us. Professor Amit Basule from Azim Premji University is there. And we have Advocate Ramapriya Gopalakrishnan from Madras High Court. Four of the speakers today will be taking us through the larger labor question and how it is going to have implications on our society and economics overall. So to begin with, I would like to call upon Professor K.R. Shyamasundar to speak to the audience.
Thank you. Thank you everyone at this. It's indeed a pleasure to be participating in the webinar. And even the title is somewhat ominous and even worrisome. And I shall, there is a lot to talk, and I see Professor Amit, Ms. Ramapriya, and of course, Comrade Amita Guha also is there, and another person from Jobs Network, and of course, Professor Amita had given a wonderful beginning. So I would restrict myself to the theme of public policy failures that characterize the pre-COVID as well as during COVID, and what should be done post-COVID. That will be my central theme. I'm not going to give the context of the labor market, and since Professor Amit is there, he is most likely to do that, but to just make an introductory remark that much of our non-agricultural sector, be it manufacturing or non-manufacturing or services, the extent of informality according to the PLFS survey 2017-18 ranged between 79 to 96, 97%. The non-manufacturing would largely be dominated by construction, and construction sector, as we know, is highly informal. So there has been a predominant amount of informality and precarity as we entered the pre-COVID, even unwittingly. But what the COVID has done is to in many ways, due to public policy failures and because of the dynamics of COVID-19, to sort of deepen the informality and widen the precarity as it would be. I mean, several organizations have been doing surveys, and I see this today or yesterday, Asim Premji University had uploaded the results of their, the aggregate results, and I'm sure Professor Amit will speak of. And we see disturbing trends of nearly 262 million, 263 million to be kind of unemployed during COVID. That's what I seem to have read. So why has this happened? Primarily because of the public policy failure and the failed public policy and administration that we have inherited from pre-COVID times. Now, as far as I'm going to speak most about the informal and unorganized sector workers. We have in place several labor laws which date back to, of course, we start with the Minimum Wages Act post-independence 1948. And then the Contract Labor Act 1970, and then Interstate Migrant Workmen Act 1979. And then from 2005 onwards, we have had a series of course, 1996 Building and Other Construction Workers Act, and then 2000, and then 2008 Unorganized Workers Social Security Act, and so on and so forth. So there is in place a legal framework, an institutional framework, a labor administrative system, however inadequate they may be. That is a point that we need to note. We have started the COVID with a certain institutional and legal and labor administrative framework, but none bothered to find out whether these frameworks have been functional or operational or not. Here lies the entire governance deficit. Very sadly, though, the Interstate Migrant Workmen Act remained mostly on paper, or rather virtually on paper, rather than being enforced. I just tried to find out, is there any annual report on the working of the Interstate Migrant Workmen Act, and I didn't find one. Maybe it's in the archives, but I have not found one. Of course, the Contract Labor Act has been notorious because of the employers' lobby and the temping agencies' lobby. However, Contract Labor Act is more to give flexibility than to afford protection to the contract workers. This is how I read the Contract Labor Act. And then the late Professor Arjun Sengupta's chaired commission, National Commission on Enterprises in the Unorganized Sector, made very significant recommendations, and the UPA, despite the presence of communist parties, the left parties rather, made a very damp squib act of Unorganized Workers Social Security Act 2008 by amalgamating the existing welfare schemes, which were dividing the workforce into BPL and above poverty line, and thereby diluting the very essence of the NCEUS. Even then, the Unorganized Workers Social Security Act provided for a certain labor administrative and governance framework in terms of constitution of boards, Unorganized Workers Social Security Board at the central level and the state level. And I browsed the Ministry of Labor and Employment annual reports. I found a parrot-like saying that in 2011, 2010-11, the central board was constituted, and according to the act, the tenure of the board is 3 years. From 2010, it has been remaining on paper since 2017-18. This speaks volumes about the tremendous amount of indifference and even apathy by the Ministry of Labor and Employment. That it also facilitates constitution of workers' facilitation centers and registration of the unorganized workers on self-declaration above a certain age, I think it is 14, and to provide them, most importantly, portable smart identity cards. It was in 2014, the UPA government started the process but gave it up. And of course, we must know that the Unorganized Workers Social Security Act excludes the informal workers who are in the so-called formal sector, like contract casual workers and others. And there was a move to include them in 2015, which was dropped. And then 2015 thereabouts, again the process was begun, and then of course the tenders were floated, but nothing came off. So, and then we have the Building and Other Construction Workers Act, and the government claims that 4.5 crore, that is 45 million out of 55 million estimated workers, construction workers are registered, but Mr. Subhash Bhatnagar and others contest this kind of registration data. According to them, the registrations could be, live registrations could be not more than 20 million or so. That is because of the tedious process of registration and renewal that is given in the BOCW Act. And of course, under the CES Act, an estimated levy, total levy of between, it ranges between, the estimates range between 40,000 crores to 50,000 crores. And in fact, the Comptroller Auditor General is not able to arrive at a particular, a concrete figure. And the Supreme Court has been seized of the non-implementation of this Act, particularly the Constitution of Welfare Boards, and it also tried to tackle the misutilization of the welfare fund in terms of purchase of televisions and laptops and others, and not for the welfare of the workers. Between 2009 and 2018, and Ms. Ramapriya is there, she will be able to talk more about that if she proposes to. But from between 2009 and 2018, the Supreme Court had passed strictures after strictures, and it had not created any sensitivity on the part of the bureaucrats or on the part of the political establishments. So we have inherited a lame duck, a lame and extremely inoperative labor administrative legal framework and an institutional framework. And what has happened after the COVID? The Ministry of Labor and Employment could merely issue advisories. That was on the 20th of March 2020, making a moral suasion kind of an appeal to the employers. And 29th March, the Ministry of Home Affairs, invoking the National Development Disaster Management Act, requiring the employers, that is factories and shops and establishments, to pay full wages and in-time wages to the workers in these workspaces. And it has been recently challenged. In the month of May, it has been challenged by several MSMEs from various places, Punjab and Bengal in particular. And the Supreme Court has stayed the coercive action that could be taken under this MHA order in case of employers in Punjab and West Bengal, and thereby raising a huge question mark as to what could be the legality of this MHA 29th order. And this apparently prompted the Ministry of Home Affairs to drop this or suspend this order in its 17th May 2020 liberalization of lockdown, and thereby taking away even the modicum of any kind of labor right that is in existence. And what did the government give apart from this? The financial relief package, the so-called financial relief packages announced EPF subventions and loans from one's own funds. And the EPF subventions covered only 16% of the total EPF subscribers, which is not a good thing to learn about, and it has been extended by the May 17th order for further 2 months. And for the migrant workers, the government could not come up with any credible assistance package. It merely provided for, of course, and in this process, I must also tell all the migrant workers suffer from multiple deficits. They have they have a statistical deficit. Putting it bluntly, they are not enumerated at all. We do not have a solid statistical base of the migrant workers. In fact, yesterday the Delhi government High Court had ordered the Delhi government and the government of India to start constituting the database regarding the migrant workers. And of course, the state governments have woken up to this fact. They have a legal deficit in the sense that the Interstate Migrant Workmen Act has never been implemented. They have political deficit in the sense they are the most politically disenfranchised class of workers that we could imagine, because they are neither here nor there. They are also welfare deficit workers in the sense that they will not be able to avail their ration facility because of the non-portability of the ration card, one nation, one ration card. And they are also socially, culturally deficit because the COVID has shown that they are trapped workers. That is, they are neither preferred by the host states nor by the home states for obvious economic and health reasons. So they suffer from multiple deficits, and the migrant workers have been left to the benevolence of the state and administration and to fend for themselves. And the Supreme Court did not respond to the several well-meant public interest litigations till mid-May, when it took suo motu cognizance of the travails and the plight and pain of the migrant workers and ordered the payment of railway fare, which if we had done in the late April, it would have saved a lot of travails and sad stories. So we have here again a judicial deficit. And of course, by curbing the coercive action, it has raised a huge question mark on the constitutionality of the NDMA Act and the MHA Order 29th March. So we are facing multiple disasters on various fronts. In the meanwhile, the unorganized workers, the informal workers, and migrant workers have been left to the market forces or the contractors, there are studies on migrant workers which say that there are though they are entitled to various benefits and other entitlements, they are hardly given any because of the way in which the construction worker system operates. There is a principal employer who is a subcontracted employer, and then he or she in turn subcontracts to the contractors who have the direct contact with the migrant workers. And these contractors are fly-by-night operators or they suffer from huge liquidity crunch. As a result, these migrant workers have not been paid by the contractors. Had we maintained a database, then some possible action could have been taken against the defaulting contractors or the principal employers or the labor supply contractors. So and on the top of it, with regard to the organized sector workers, so far 12 states today, Tripura, I think today Tripura has introduced an order to increase the maximum hours of work along the lines of the other states. So far 12 states have done it, of which 2 states have withdrawn. One is UP because of the litigation that took place in the Allahabad High Court and withdrew it. And of course, Rajasthan, perhaps due to the pressure exerted by Congress government, withdrew it. In fact, Rajasthan was the first state to legislate this ordinance even before the liberalization of national lockdown on April 12th, 2020. So now, as of now, 10 states have extended the working hours. I want to talk about this, the consequences, labor market consequences. It imposes a gender penalty in the labor market. Gender penalty in the sense that 12 hours of work and 2 hours of travel time, nearly 14 to 14 and a half hours, depending on the metro in which one lives, will be consumed by the women workers. And given their multiple dimensionality, on the supply side, women workers are less likely to offer the labor services. On the demand side, because of the cost of engaging the women workers with adequate protection and the private transportation, the employers would prefer the male workers to the female workers. So already the female labor force participation has been driven down to less than 20%. And if you go by the CMIA data, the labor force participation has declined along with the decline in the unemployment, which is a paradox. Of course, the situation has reversed a bit during May. So it is a gender penalty. It is also a maternity penalty in the sense that pregnant women and those who are close to maternity are less likely to offer the labor services for the fear of getting infected. And given the health infrastructure, it is advisable that they did not offer. So it is not fair on the gender sense. It is not fair on the social identity sense, in the sense that the caste workers, the scheduled caste, scheduled tribe, and OBC workers are already face labor market discrimination, and they would face much more more discrimination in terms of employment opportunities. And also, given the SOP and others, it is the regular workers who are on the muster roll are more likely to be asked because of the 1/3 rule that the SOP requires for employment. And then we had this, so these are, and of course, the entire Factories Act amendment, of course, has been challenged in the Karnataka High Court because Section 5, which the several state governments have used, will not stand the test of legality. I'm sure Ramapriya will talk about it, so I will not talk dwell much on that. But what is important is that the hours of work has restricted the employment opportunities and created informal, precarious workers, and even which have health and safety implications, because the longer the hours of work, greater the fatigue and greater the probabilities of safety and health issues. And then we had this fantastic regulations by MP and UP, and I will make just 3 points about that. All these laws together have combined together have what shall I say, deprived of the workers of their hard-won, constitutionally conceived basket of labor rights, that is the right to form trade unions and have them registered, right to collective bargaining, right to recognition, right to raise industrial disputes, and right to the access of conciliation machinery and the labor adjudication machinery, and even the right to strike, because the strike provisions will also go for a toss. And the wholesale suspension of the labor laws by the UP government poses constitutional arrangement questions that when in the last webinar, when I had a conversation with Ramapriya, she had very correctly described it as creating a legal vacuum. In other words, we are going to a lawless society, which even the 19th century employers would have put them to crimson face. Even they would have been shocked that in the 21st century we are making retrogression to the 19th century. So we have, as economic students, we have heard of tax holidays. Now we are coming up with labor law holidays for 3 years or 1,000 days. And these laws have been, while the national codification process is going on, the state governments have utilized the COVID-19 induced labor shortages, or so-called labor shortages. On the one hand, we have labor shortages. On the other hand, we have 26-27% unemployment. So in labor economics, we would generally leave these situations to be tackled at the micro level rather than going for a macro solution, because it would have been left to the social dialogue between the firms and the trade unions to sort out the issues pertaining to the labor shortages. So what we have done effectively is that we have gone for uncalled for macro solutions without social dialogue, and thereby either the process of lawmaking or the actual clauses that are contained or not contained, to which ironically, they violate the various ILO conventions from the tripartite consultation C-144 and Labor Inspection Convention C-81 and 001 Hours of Work Convention, the first one the ILO adopted soon after its formation. Directives and regulations and the advisories provided by ILO during the COVID. So I'm coming to the last part of my speech, and the central trade unions, the 10 central trade unions have done their best to take forward these issues to the International Labour Organization. And to the best of my knowledge as a student of labor history, Perhaps this is the first time that the Director General of a United Nations body like ILO has thought it fit to write a letter of persuasion and appeal, and even expressing somewhat in stronger terms the disapproval to the Prime Minister of a country that the proposed labor law reforms, I mean, they can't be called as reforms because reforms as a ring of positivity, disruptions, I would say, are not in compliance with the international treaties. Now, I have three suggestions. The national code making has been also unsatisfactory because it has not been done with social dialogue and not much thought has gone into it, save for the Parliamentary Standing Committee scrutiny of it. I make three suggestions. Suggestion number one is that the central government, as it has been making some indications in the press, should suspend the state law amendments with immediate effect, thereby putting confidence in the minds of the workers to assure them that it is a welfare state and it cares for them. And also tell them that the national law code making is on and these issues will be dealt with. Because there is no scientific evidence, Dr. Rahul Sapkal and I have argued that if at all we have to make a very cautious statement on the impact of labor law regulations on the employment or investment, the jury is still out. That is the best cautious statement I could make. So secondly, the social dialogue process must be actively initiated and meaningful and pragmatic and effective social dialogue should take place. And thirdly, any person who has a decent semblance of law would see the codes have been ill-drafted. And I think we are a country of very proud IAS officers and have a rich base of lawmaking intellectuals and academics. And the government should constitute, and the trade unions must demand the government that they should constitute an expert committee in order to redraft the codes in consultation with the ILO. That is my third suggestion. The government of India and the central trade union should write to the ILO along with the employers organization and seek technical cooperation in terms of lawmaking. Along with that, an expert body should be constituted with a suitable composition. And there is no need hurry to push through the code making. I mean, let us say the NDA government wants to do it. It still has got for 3 more years, and 1 year could be spent, like in China, they spent 2 years in making the 2006 labor contract law. And I also wish to maintain that a monolithic, non-democratic country like China held wide consultations with ILO and sought its technical cooperation in order to make their labor contract law and the mediation and arbitration law. And India is a pluralistic democratic country, and we have a constitution, we have international treaties. So I strongly urge the central trade unions to take it forward with this. I know the government is not listening to them, but there is no other channel we have in to ask for an expert committee to address, to redefine, to redraft the labor laws, the labor codes in the light of the COVID-19 experiences, and design the labor law and administrative system and an active administrative system. And if, for example, providing for national unemployment allowance and assistance and insurance scheme, which the Second National Commission on Labor 2002 recommended. So we have a good amount of material, NCUS and others, and we could go about it. There is no hurry.
Last one.
Yeah. There is no hurry on the part of the government to push through the labor law reforms as if they would bring in billions of dollars, which otherwise would have gone from China to Cambodia or Vietnam. And there have been enough articles to show that the space vacated by China, of course, there is no vacation of space in China. That is what the Financial Times correspondent has written. There is no space vacated by China. China is a tough, the nation, a society, a polity. If at all the space vacated by China, it cannot be occupied by India, mainly by liberalizing labor laws in an aggressive and blanket manner. There are other issues like energy, infrastructure, and others. The World Competitiveness Index constituted by IMD shows that India doesn't have infrastructure on multiple dimensions. That is where the government should look at, not the labor laws. And so I reiterate that
Sir, last 1 minute.
labor laws can wait for a bit of time, and we could go about it through social dialogue and technical cooperation from ILO and constituting expert committees to review the national codes in the light of COVID-19. Thank you very much.
Thank you, Professor K.R. Shyam Sundar. Now our next speaker, Ms. Sabina Dewan. She's the founder and executive director of the Just Jobs Network and also a visiting fellow at the Center for Policy Research in India. Please, Ms. Dewan, you can address.
Thank you. Could you please enable screen sharing? I do have a presentation, so I can share my screen. There we go. Okay, great. So first, of course, I'd like to start by, saying that it's a tough act to follow Professor Shyam Sundar. And of course, I want to start by thanking Corporate Responsibility Watch, Workers' Solidarity Network, and of course, TIS and Rahul Sakpal in particular for inviting me to speak today. I wanted to start just by talking a little bit about my organization, and just for those of you that don't know, as Rahul mentioned, I am also a senior visiting fellow at the Center for Policy Research, but I also run an organization called the Just Jobs Network that has been working since 2013. So some may say we're still quite young in the Indian context, but I've been working with private sectors, the private sector policymakers and grassroots organizations to find evidence-based solutions to what we consider to be one of the most pressing challenges of our time, which is how do you harness the productive potential of people to build better livelihoods, economic security, and more inclusive economies in a rapidly transforming world. Why did I feel the need to sort of start with this? Because Just Jobs Network has been working on what we call the transformations angle for a while. Our world has rapidly been changing for some time now in the face of forces like technology, migration, urbanization, trade, and climate change. And in that sense, we should be very adept by now at dealing with crises, because we've been confronting several very big transformations for some time. And yet we are not. And this crisis, the COVID pandemic, has really highlighted the real problems that we have with our institutional structures and with policy implementation that has left millions of workers extremely vulnerable in the face of this current crisis. And we actually have no excuse. This is, I go completely nuts when people say the new normal. The thing is that there's nothing new about this. The way that we've been treating workers in this economy has been the normal for a long time now. And if anything, we have this opportunity right now to really rebuild in a way that promotes better livelihoods, that promotes greater economic security, greater equity. I always start these presentations by asking myself why, despite a lot of academics and practitioners and nonprofits and extremely well-intentioned, smart people, does India confront such large and seemingly insurmountable problems? And India is unique in the sense, I do have the luxury of being part of an organization that does work globally. And so I have the advantage of doing some comparative work. And here I feel that India has a massive scale, which can be both a advantage and a disadvantage, right? We have a 1.3 billion plus population. We have just under 500 million in our labor force. Our youth population alone is, people between the ages of 15 to 29 are, 361 million roughly. That is higher than the entire population of every other industrialized country in the world. So we are dealing with this massive scale. And one of the problems when we talk about scale is that our policies become so top down, and the implementation, the heterogeneity of our country demands decentralized implementation of policies. And yet often we are doing sort of top-down instructions that don't actually fully account for the heterogeneity of our population. So what do I mean by heterogeneity? And I'll go into that in more detail. And the fact that we've had very persistent weak institutions and poor policy implementation for some time now. But let me start with talking a little bit more about heterogeneity. Of course, labor status, right? So just to give you an illustration, we have this very massive category of self-employed workers that has remained relatively consistent, or has remained actually almost exactly consistent between 2012 and 2018. And the point is that as our economy becomes more as these transformations, everything from technology to migration to climate change, and now with this COVID pandemic, as these transformations act on our labor markets, these kinds of heterogeneity and the diverse impact of these transformations on these different segments of our labor market becomes really hard to account for, and to account for in policy. So, one big example is, of course, gig workers. We're all privy to the fact of this constant discussion about, gig workers are considered self-employed workers, and yet these technology intermediaries exert a very high degree of control in terms of wage setting and price setting, in terms of their working hours, in terms of the, in terms of their incentives and so on. And so really they're not self-employed workers. They're actually working for an employer, and yet in law, this is a completely gray area, which we don't know how to regulate. So the point here is that the heterogeneity of our labor market, makes it really hard for us to account in specific laws, and there's legal experts on this panel, so you're welcome to agree or disagree and respond to this, but it makes it really difficult to respond in law. And as the world changes, these categories become less and less relevant. Another one is the formal and informal dichotomy that we have been relying on for decades now. And when we actually look at the level of precarity in formal jobs, it's astounding, and that dichotomy becomes a lot less, I would say, relevant. The idea here is that the fundamental point is that we have jobs with varying degrees of productivity, a very high number of very low productivity jobs, which have very poor wages. And there's been a sort of decoupling of productivity and wages. And yet, but we also have to sort of think through that, does this formal informal dichotomy still hold? Again, I go back to the example of gig workers, right? Are they formal workers? Are they informal workers? When we talk about regular wage workers that don't have a job contract, this number is astounding to me. It has gone up from 65% to 71.1% in 2018. These are 71.1% of regular wage salaried workers do not have a job contract. 54% do not have paid leave, and 50%, just under 50%, 1 out of 2 do not have any social security. So this dichotomy between formal and informal, and these sort of ways in which these frameworks that we have applied to our labor market for some time now are no longer applicable in this rapidly transforming world that we live in. And then, of course, how can we not talk about the complex geography of labor migration and contextualize this discussion in the COVID and post-COVID world? Migration is not a new phenomenon. The lack of portability of benefits is not a new phenomenon. You know, and yet, I mean, it's just, to me, it's completely mind-blowing that we would go into lockdown and not think about the fact that there are daily wage laborers and migrant workers, you know, 6 to 8 people to a small room that rely on getting food from outside, that don't have, you know, any provision to cook in their little rooms in the jugi. They don't, you know, that we could institute and go into this stringent lockdown without actually acknowledging the fact that we have a large number of migrant workers, daily wage workers, that have absolutely no means of livelihood. And if I may just tell you a little anecdote, on the Sunday when the first lockdown was declared, I called a friend of mine in the food department and I said, what is the government doing in terms of food provision for these daily wage workers? There's a big informal settlement right across the street from me. I know a lot of the workers there. I was aware that these workers would have no provisions the next day. His response to me was, don't worry, the government's taking care of it. 5 days later, he calls me back and says, see, they're now providing cooked food in the school right across the street from you. And my response to him was, I would love to see you, and you know, I would love to see you go without food for 5 days with no way of cooking, no way of buying food, you know, having the stress of not having a daily wage and not knowing how long the lockdown was going to last or how you were going to pay your rent. But these are not, these kinds of precarious work conditions are not new. They've been brought to the surface by COVID, but they have been a result of a failure on part of our policies and on part of our governments and policy thinking on how to build institutions that are actually, you know, nurturing of livelihoods, nurturing of greater equity, that put people at the center of economic growth strategies, which we haven't done in a long time. So how does this manifest? Well, it manifests in a labyrinth of labor laws, over 150 laws, right? The heterogeneity, the scale, you know, what do we mean by weak institutions and failure of policy, other than the sort of anecdotal evidence I've already provided you? We have a labyrinth of labor laws, 150 laws, and the new, and I'll get into a little bit more about the new codes and so on. We have very poor social protection coverage and wasteful subsidies. We have over 600 central social protection schemes. And, you know, as I said, even if we look just at regular wage workers, 50% of them do not have any Social Security coverage. We have very, you know, under investment or poor investments in human capital. And here I'm specifically referring to education and skills training, and I'll talk a little bit more about that. And I won't talk about this, but I think it's worth noting that we have an extremely fragmented labor union movement. You know, I am a very strong believer in social dialogue and in building strong industrial relations. There is plenty of evidence from Germany and a number of other countries. Someone asked a question about, you know, India relative to Vietnam, and I can talk a lot about Vietnam because I think it's the country to watch in terms of its growth and rising living standards. But, you know, even Vietnam is considering, and since the TPP, the Trans-Pacific Partnership, has been willing to and has understood the need for social dialogue, for strong social dialogue. India has a vibrant union movement, but it's an extremely fragmented union movement, which makes it really hard to have a very concrete message that you know, needs to be sent to governments and to employers on how to improve conditions. Now, I know I may be walking into a minefield with this particular audience, so you know, I'm very happy to be corrected and to hear what you all have to say. But I thought I would put that out on the table nonetheless. And I see Professor Shamsun, they're nodding. So anyway, moving forward. So as I said, we have a labyrinth of labor laws, 44 central and over 150 state. You know, I think this is fundamentally important. I'm basically just underscoring what professor just said before me, which is that the evidence that labor laws are responsible for constraining the growth of businesses is at best extremely weak, right? There are huge other bottlenecks that our businesses grapple with, everything from registering a business to numerous compliances to, to infrastructure bottlenecks, to shortage of land and electricity, to lack of access to finance. And these matter so much more than labor regulations. In fact, India, and I mean, if we just take a step back and look up, look beyond just what we're seeing on paper and ask ourselves, what is the actual implementation, for better or for worse, of our labor laws been? It's been abysmal. So if these labor laws exist on paper and aren't actually being implemented, then wouldn't you say that India has one of the most flexible labor markets in the world? And yet we have not seen rising living standards, and we have not seen labor market conditions improve. In fact, as Amita mentioned in the beginning, we're actually seeing, even before the COVID crisis, a downward trend in terms of several of our labor market indicators, and I highlighted a few in my opening remarks. So, the idea that we pin all of this to labor regulations is it's overly simplistic. It is not going to be it's not about more or less regulations. It's actually about better regulations that are clear. We have done a lot of work with various private sector companies, both domestic and foreign investors, and they will tell you that to use a phrase that I'm stealing from Manish Sabharwal, the regulatory cholesterol that exists is much more of a deterrent than labor regulations. And in fact, contrary to popular belief, the clearer and more stringent the labor laws are, the more comfortable companies, at least certainly foreign investors, feel in terms of being able to invest in a country and knowing what to do, as opposed to sort of coming in and having all these gray labor laws and being dragged into court without, at a whim, without really knowing what you're being dragged into court for always. So there's a lot more work to be done in terms of the simplifying, clarifying, harmonizing these multitude of labor laws into the 4 codes. Only the wage code has been enacted, and we're still awaiting the rules. But if you actually read through the text of the various codes that have been proposed, they are abysmal in terms of actually laying out clear regulations. We can debate what those regulations should be, but the first step is, let's at least be clear. These codes are extremely vague. Anyone can put anything in them, and that does nothing for actually bolstering business sentiment. Someone in the chat box also asked questions about, China relative to India, or Bangladesh relative to India. And I would say, first, with regards to Bangladesh, we do not want to be Bangladesh. Bangladesh is trapped in a very low value add, one sector economy, where an oversupply of labor in the apparel and garments industry is seriously depressing wages and working conditions. We saw what happened with Rana Plaza and the withdrawal of the GSP preferences that came after that. The country is extremely vulnerable. And yes, it's had high rates of economic growth built on the back of workers in the apparel sector, but it has not seen rising living standards. And so we do not want to be Bangladesh. With regards to China and Vietnam, Vietnam is diversifying its economy. China actually has very clear regulations and has been, in the last decade, been investing very heavily in social protection, to kind of raise living standards of its workers. And all the discussions that we hear now with regards to rising wages and moving to higher value added activities in China, that companies are going to migrate out of China into other countries is sort of, is sort of underscores this idea that China has actually been raising living standards. And so there's a discussion there about more about economic freedom and political freedom. But the labor regulations debate, I don't think it's not comparing apples to apples if we're comparing India and China in that context. With regards to social protection, in 2020-2021, the government allocated 27.3% or 8.32 lakh crore for over, as I said earlier, 600 central protection schemes. And this excludes state-run schemes. Of these subsidies, 2.6 lakh crore, of these subsidies accounted for, I'm sorry if you can hear my dog barking in the background, subsidies accounted for 2.6 lakh crore. And
Last 2 minutes.
oh goodness, okay. Well, the point here being that jobs can change lives in the way that no subsidy can, and we really need to reconsider our subsidy system in order to actually put resources toward more social protection and better social protection for workers. My system has completely jammed up. Sorry. Are you all able to, are my slides changing? Are the slides changing?
No.
No.
Okay.
Yeah, now there.
Education and skills, our spending on education is woefully inadequate. Skills training does not compensate for years of poor quality education. Technology itself, and now the impetus for online learning, cannot be a solution by itself. It's important, it's a part of the solution, but a human interface is critical. So, very quickly, what to do? Basically, I think on the demand side, we will, of course, need to, I've focused a lot on the supply side, but we, of course, need to, in the post-COVID world and all the economic pain that we've caused, we will need to figure out how to revive and rebuild productive businesses through, excuse me, through loan moratoriums, ensuring access to capital at low interest rates, removing barriers to the formation of new businesses, being consistent with and making it easier for business filings and compliances. Governments can also support businesses through wage subsidies. So we keep talking about tax moratoriums or reducing taxes, but I think it's worth considering wage subsidies that are paid directly to workers as opposed to the businesses. And of course, we need to think about the composition of growth and what sectors we incentivize here, focusing on more labor-intensive sectors. Investing in infrastructure is key. I'm sorry, I'm just going to kick my dog out of the room. Hold on. I'm so sorry. Okay, we need to invest in infrastructure. Infrastructure development creates large—
Last 1 minute, Sabina.
Okay. Creates large numbers of jobs, but the quality of construction jobs leaves much to be desired. And here we need better occupational safety and health standards. But this also speaks to the question of how do we actually create jobs in some of the rural areas where migrants are going back to. And here I think infrastructure is absolutely key, even for improving agricultural productivity. And I think an expansion of Manrega to this end is fundamental. I've already talked extensively about making labor regulations simple and effective, but equally important is effective implementation. So not just having them on paper, but actually effectively implementing them. Instituting wider social protection. The way we account for the heterogeneity and the scale of our country is by moving toward greater universalization. I know Professor Amit Basole has talked a lot about universal provision of services, and I think that's a fantastic idea, and I would love to hear more about it. Hopefully you will talk more about it now. do away with wasteful subsidies and use direct benefit transfers to provide a streamlined set of health, maternity, disability, bereavement, and pension benefits. This is a controversial one, but I'm going to put it out on the table. Make EPF and ESI optional. Happy to speak more about it and learn more about this issue. And reform education and skills. India's education and skills training systems are in desperate need of an overhaul. And these will demand greater funds, but equally importantly, they will demand acknowledgement of sunk cost. Things have not been working. Let's accept that and remake the systems. So thank you very much. That was a lot, but I look forward to your questions and comments. Thank you.
Thanks, Savita. Now we can have Professor Amit Bosole from Azim Premji University. Please.
Thank you. Thanks, Dheeraj. Thanks, Rahul. And thanks to the organizers for inviting me to this very, very timely and interesting event. Am I clearly audible?
Yes.
Okay.
Yes, please.
Okay. So I think a lot has already been said by all the three previous speakers. So I'm think I will focus more, and also combined with the fact that a lot of things have been covered and that labor laws per se is not my area. I will focus rather on some broader structural economic issues, place the labor law question in a framework that I feel, I hope will be a little helpful for us to think through this. Before I do that, since I think some mention was made of our survey on COVID lockdown impact, I just wanted to share with you some very brief updates on that. If I may share my screen, Dheeraj. I'll just show you a website, our website, where we have been gathering some information so that some of you, if you want to go and look at it later, you can also do that. This is on the website of the Center for Sustainable Employment at Azim Premji University. This is our sort of one page for a lot of COVID work that we are doing, including the phone survey of 5,000 workers that we have finished. As well as a compilation of other surveys that have been done, including one very good one by ActionAid, of which Rahul was a part in Bihar. So I'll just show you a little bit of this, and then I'll come to the core part of today. So one of the things here you will find is a dashboard that basically summarizes our findings on employment, earnings, as well as access to relief measures, etc. I won't go over the findings right now. Suffice to say that I think everybody knows that this has been a massive shock to the economy, particularly to the informal economy, but through multiplier effects and general macro effects, it's going to be the whole economy that will be severely affected. A large loss in employment, as you can see, a large loss in earnings, a very large proportion of households who reported to us that they were consuming less food than they were before. A significant percentage, 50% almost, who said that they had enough money only to buy a week's worth of essentials. Mind you, this is not a representative survey. This is a very purposive sample of vulnerable households. So I'm not making any claims about the Indian workforce. I'm only making a claim about the 5,000 people that we spoke to. Nevertheless, the cross-survey work that we are doing, we've collected and archived about 30 surveys that have been done, and I'll show you that too in just a minute. I think tells us that these effects, these findings are not limited to our survey. So anyway, coming back to this, we have a dashboard here that you can explore, on your own time, which looks at these key findings as well as some impacts on households and so forth. And then we also have, I'm scrolling down here to a state level dashboard where you can select, among the 12 states that we have done this in, you can select a state, and that will also give you a sense of what we find for a particular state. Again, on the same key dimensions of loss of employment, loss of earnings. There again, we find a fairly widespread effect, particularly among vulnerable households. So this is the state level dashboard. And then finally, I'd like to point you to there's a spreadsheet here that we have been maintaining over the last few weeks that essentially is just a simple compilation of COVID lockdown impact surveys that have been done by various organizations, academics, civil society organizations, think tanks, consultancy type of organizations, and so on. So you'll find a fairly long list here. Some of you may know some of these surveys. So we've tried to archive the period of the survey, what kind of population was surveyed, where, what were the issues surveyed, as well as a link wherever available to reports, questionnaires, and so forth. So I'm just scrolling to the list here. You'll see there's a fairly large list. I think as of last count, about 30 odd surveys are here. So again, please feel free to come here and visit this. Look at the surveys. We are working on a kind of a piece, short article that combines gives us a sense of what are the common minimum insights that are coming from these different surveys. Since all of these surveys have been purposive, none of them can claim to be representative in a statistical sense, except of course the CMI survey, which is an ongoing nationally representative survey, which is not over here. So since they already put out their bulletins, we have not done that. All of these surveys are very purposive in a non-random surveys, but we think that across them, a good understanding can be built up of what has exactly happened as a result of the lockdown. Okay, so that's all I wanted to show by way of sharing my screen. So let me stop that and use up whatever little time I have. I won't go for very long since most things have been said. So as I said, let me frame the labor laws debate in a way that I find helpful to do in a structural sense, where India is as an economy. Start from that point of view. So what we know when we look at the structure of the Indian economy from a cross-country perspective is that our structural transformation has been a little bit different from some of the other peer developing economies. And by peer, I mean economies that would have had a similar level of per capita income, let's say in the 1950s, where there would be countries as diverse as Korea, China. Many of these countries would have been in a very similar position in 1950, but the way economic development has unfolded subsequently is that in the Indian case, we still have a fairly large proportion of workers who work not only informally, as we have already seen, but also in the micro enterprise sector. So most of our enterprises are very small in size. The average scale of an Indian business, whether in manufacturing or in services, and of course in agriculture, is still very small. We are talking to the order of single-digit number of workers or 20 workers and so on. That's where most of our businesses are. And that creates a very peculiar problem for regulating the capital-labor relation, which is what we are talking about here. So as all of us know, and this doesn't really bear repeating, but just for completeness, we are talking about capitalist economies which have a fundamentally antagonistic capital-labor relation, which needs a third-party regulatory framework. No matter how much we say that the interests of workers and capitalists are aligned, there is still also a fundamental class contradiction there. So the role of the state is obviously always present. Further, when we talk about an economy like India, where the vast majority of firms are small and the vast majority of labor markets have an excess supply of labor in them. So we have not too many of our labor markets are tight. Most of them are fairly loose. You put that two together, then you understand that the role of the government in such a situation is very, very important. Because first of all, workers are very disaggregated so that only 20, 30, 40, or even less than that number of workers may have an employer. So that has some implications for collectivizing and collective bargaining with employers and so forth, at least at the single firm level. Obviously, I understand that unions are not single firm entities, but still there is some complexity here that is introduced by the problem of scale. That's one. And the second being, India being a labor surplus economy, the bargaining power of workers is structurally weak. and it has remained so for many years. So employers are in a much more powerful position vis-a-vis workers in India in almost every sector, and that makes it even more incumbent upon the state to devise safety and social protection and so forth for workers whose rights will be threatened. I mean, there is no way that they won't be in the kind of structural framework that we are seeing, which the Indian economy is in. Right? So it cannot be left to the goodwill of employers. It has to be legally enforced. Nothing new here, but just laying out the basic idea. Now, that brings me to the trickier part, that given fiscal constraints or given administrative constraints, given that the capacity of the state to enforce what it thinks should be the social protection regime, that capacity is of course limited. It's a scarce good like any other good. The question is, how should it be spent? How should that administrative capacity and that regulatory capacity be spent? And the way we have by default done it so far is that to the extent that we have spent this capacity, it has been focused on a small proportion of the workforce, and the rest, which includes, of course, self-employed workers as well as casual workers and so on, have been left to fend for themselves. So there is a fair degree of inequality in terms of the spending of regulatory capacity. Where does the Indian state actually make sure that something is happening in terms of, let's say, minimum wage laws, working conditions, working hours, occupational safety, health, all of these things? Where do we actually spend those resources and where do we not? And what we see is that the vast majority of workers do not have that access to that regulatory system. So here comes the somewhat more controversial point, is if the capacity is limited and in the short run not very much extendable, then how can it be rewired or re-engineered to ensure a non-negotiable floor to every worker without substantially cutting back on the protections that are enjoyed by the most protected workers? So there are several political economy challenges here about who is more protected, who is less protected. Can the floor be brought up completely to where the most protected workers are? And if regulatory constraints or capacity does not allow that, what kind of non-negotiable floor are we talking about? Where we can say that this much is guaranteed to every Indian worker. We know that the full degree of protections cannot actually be guaranteed to every worker. And of course, here I'm very welcome to be corrected. I'm not an expert in this field. And Professor Shamsundar, Sabina Diwan, Advocate Ramapriya will all know more than me about this particular thing that I'm treading into now. So I welcome thoughts on this in the Q&A. What I'm saying is, going forward, if we wanted to have non-negotiable floors on conditions of work, what would they be? Could they be enforced with current levels of capacity that we have? What would need to change for that to happen? And would that result in a loss of protection anywhere, or can it be achieved by maintaining the existing levels of protection wherever they are present? That's essentially the question I'm raising. Now, let me switch. So that's one question that I wanted to pose. And of course, I'm very aware that the character of the Indian state is very important here. If the Indian state has not demonstrated a capacity to act in interest of labor in a systematic way at all, and particularly not in the neoliberal period, but even earlier, as we know, most of the laws remained on paper. Professor Shamsundar has written very insightfully about this for many years now. So the fact that the Indian state cannot discipline capitalists and cannot protect the interests of labor is clear. So we need to take into account what are those reforms that we are talking about. How does the Indian state itself need to change in the way it is representing class interests here? I mean, we cannot wish away that question. Okay, so the second broad point that I wanted to make was about the type of what do we talk about when we talk about labor laws and protection of labor and so forth. And here many people have pointed out the distinction between conditions of work So legislation and protection that pertains to things like minimum wages, working hours, safety, right to unionize, or these kinds of things which pertain to the conditions of work of workers, and regulations that pertain to the job security aspect. This is the famous hiring and firing laws, right, which have received so much press. 5B of industrial disputes and all of that other kinds of things, where supposedly we are inflexible or rigid and so on the ability of employers to hire and fire. So if this distinction is useful at all between job security related regulation and working conditions related regulation, I would like to make one simple point, which is if the government wished to create better job security, then from a very simple surplus labor point of view that I approached the matter at the beginning, exhausting those surpluses of labor is the single best thing that can happen to the Indian labor force. This goes back to my earlier point about the failure to structurally transform the economy. If the government can ensure tighter labor markets, and I will come to that in just a few minutes, what are the ways of doing that? Those tighter labor markets go a long way in ensuring that there is job security, not of the kind that we are used to when we think of permanent jobs and so forth, where workers cannot be fired and all of that type of thing that has been discussed a lot, but job security of the kind that I know that if I lose my job, the labor market is not so slack that I will never find another, which is really what makes workers desperate enough to accept a lot of these kinds of conditions that we are talking about. Tight labor markets give a certain bargaining power to workers that automatically result in better working conditions. So where do these tight labor markets come from? Obviously, they come from job growth in the private sector, but also from the public option, which is where employment guarantees play a very important role. So let me talk very briefly about these two things. First, the public option. I'll just get that out of the way because the private option is a trickier issue. The public option, simply what I mean is, Manrega was mentioned earlier. It is a very important safety net in the rural economy. We need to think of a similar net in the urban economy. I think the COVID context has shown us clearly that if we had something like Narega for the urban economy, things would have been vastly different. Not immediately because of social distancing and so on, but now as the lockdown is being removed, many workers would have had some degree of confidence that their earnings would not continue to be zero for the next 4 or 5 months, which is, I think, what most workers saw, and therefore decided to reverse migrate and all the rest of it. An urban employment guarantee program would stand us in very good stead to tighten the urban labor market and take care of some of the bottom rung issues that we have on working conditions. That's the first very important public option that we need to think about going forward. The second—
5 minutes, sir.
Sorry? How many minutes?
5 minutes.
Okay, thank you. The second, what Sabina mentioned, which is the universal basic services idea that we have been talking about. Both of these things, urban employment guarantee and universal basic services, were policy briefs that we put out last year. They are on our website. Here, the idea is simple, that we have vastly underinvested in public services, health and education, to take, of course, two obvious examples, but also housing and so forth. So we need to invest there, and we need to do that by way of job creation. I mean, these are services that need to be provided by someone. So two goals are met here: provisioning of services and creating of jobs, which again is a public option here. So this is what I wanted to say about what do I mean by the public option in tightening labor markets for improving the bargaining power of labor. The second trickier issue is the private job creation aspect. And here, of course, there has been a lot of writing here. Many of you would be familiar of why have we failed to create jobs. This connects back to the first point that I made, which is that the Indian experience, unlike the Korean or the Chinese or the Vietnamese, has been different in that we have failed to scale up our firm size and failed to create employment in the proportion that growth would demand. So our elasticity of the growth elasticity of employment generation is very weak. We may grow at 10%, but employment barely grows at 1% or something like that. And that means a continued slack labor market, a continued dominance of self-employment, which Sabina showed earlier on in the statistics. So the failure to tighten the labor market through private job creation creates a continual pressure on bad working conditions and sets up this problem that we have of labor laws. And we simply cannot correct through, this is my opinion, again, welcome to be corrected in the Q&A. I don't think we can correct merely through regulation what is essentially a structural problem of low bargaining power of workers. Right? So that problem has to be addressed center stage for any regulatory framework to do its job. Otherwise, we are just up against a very powerful market force that is very difficult to do anything about, particularly given the context of the Indian state, which cannot discipline capital and consistently takes an anti-labor stance. That character of the Indian labor state, unfortunately, has not changed for decades, and we can discuss why that is the case. Last point in a couple of minutes that I have. This kind of, to bring together what I have mentioned, what I think going forward would be good to debate is how do we think of these floors? How do we think of the diverse business landscape that exists in the country? The MSMEs are very different from the corporate sector. They face very different challenges. They face different labor law landscape and other landscapes, or the other infrastructural landscape and so forth. So for MSMEs, what do we have in mind to help them deal with the regulatory framework that confronts them? What do we have to help them deal with the costs that they bear for labor regulation often, which are actually not explicit costs? These are not costs of, paying labor, social security or anything like that. These are simply costs to avoid labor regulation. And of course, many other kinds of regulation too. So a lot of small businesses are bearing costs simply of bribery, basically. What do we do about that? So that those costs are either not borne by them or they are made explicit costs, which go to the exchequer instead of going in private pockets. Can we combine that with helping them grow larger in a way that does not punish them for growing larger? And this, of course, circles back to the labor laws issue. So these are the big questions that I would like to leave with us for Q&A. And would be very interested to hear, particularly the opinion of people who know much more than me in this regard. Thank you.
Thank you, Professor Basul. Our next speaker, Advocate Ramapriya Gopalakrishnan from Madras High Court. Just to give heads up, we have to extend this webinar by 15-20 minutes. I think by 25 minutes at least, to accommodate some of the questions. Our apologies for this inconvenience. Please, Advocate Ramapriya.
Good evening, everybody. First of all, I would like to thank Rahul Sapkal for inviting me to be part of this webinar. So I would like to begin with a few introductory remarks about a broad analysis of the law and policy responses of the government in the wake of the COVID-19 crisis. In the wake of the COVID-19 crisis, various announcements have been made by the central government, and then there have been these labor law changes that have been made by the state governments. So this is what I refer to as the law and policy responses of the central government and the state government. And I would like to first say that an analysis of these responses will indicate that these law and policy responses are grossly inadequate. Now, why are they inadequate? They are inadequate because first, they are not structured on the basis of social dialogue with the relevant stakeholders. So they're not structured on the basis of social dialogue. That is one major shortcoming. Then they are not human-centric. They are not worker-centric. And they are oblivious of the impact that they have on workers' rights and workers' interests. So again, that flows from the fact that they are not human-centric and worker-centric. Now, coming to the changes in labor laws made by the state governments, the changes made by the state governments, I would broadly classify them into 4 categories. One is extension of hours of work. That has happened in 14 states totally. And now 2 states have gone back on that. That is UP and Rajasthan. So as of now, as on date, 12 states have extended the hours of work. In most states, the hours of work have been extended to 12 hours a day and to 72 hours a week. And this was never envisaged under the Factories Act. Under the Factories Act, inclusive of overtime work, the maximum hours of work can be 60 hours in a week. So that is 48 plus 12. And so this is in violation of the existing standards under the Factories Act. And this is also obviously in violation of the international labor standards, which is the standards contained in Convention number 1, the very first convention of the ILO Convention number 1, the Hours of Work in Industry Convention, which India has ratified and is therefore bound to strictly implement. So this change, this extension of hours of work to 12 hours a day and 72 hours a week, this is also unconstitutional. It is in violation of international standards. It's also in violation of the fundamental rights guaranteed by the Indian Constitution. Because the Indian Constitution, the Supreme Court has interpreted Article 21 under the Indian Constitution to include the right to health and the right to just and human conditions of work. So this change violates fundamental rights, it violates human rights, it violates international labor standards, and it undermines the existing protection that workers have under the Factories Act. Then the second kind of change is exemption from labor laws. Now, exemption from labor laws, 3 states have resorted to that. The first is the state of Uttar Pradesh, then there is Madhya Pradesh, and then there is Gujarat. Gujarat is also proposed to bring out an ordinance, but the text of the ordinance is still not out in the public domain. Now, the state of Uttar Pradesh, what it has done is it has exempted all factories and manufacturing establishments in the state for a period of 3 years from the application of all labor laws, with the exception of the Bonded Labor System Abolition Act, the Employees Compensation Act, Section 5 of the Payment of Wages Act. Section 5 basically just says that wages should be paid on or before the 7th day of every month in factories employing up to 1,000 workers, and in factories employing over 1,000 workers, they can pay wages up to the 10th day of the succeeding month. So that is what Section 5 says. And the fourth provision is provision which still will continue to apply is the provisions relating to the protection of women and children in labor laws. It says it very generally. It doesn't say which labor laws, which provisions, but they say the provisions in the labor laws relating to women and children will continue to apply. And then it's also mentioned that the safety provisions in the Factories Act will continue to apply, and the safety provisions in the Building and Other Construction Workers Act will continue to apply. But basically what this means is the legislations which will not be applicable to factories and manufacturing establishments in the state of UP for a period of 3 years are: 1, the Trade Unions Act will not apply, the Industrial Disputes Act will not apply, the Industrial Employment Standing Orders Act will not apply. Then the other provisions in the Payment of Wages Act relating to unlawful deductions from wages and so on, they will not apply. The Payment of Bonus Act will not apply. Then when we look at occupational safety and health, the health related provisions in the Factories Act will not apply. The Dangerous Machines Act will not apply. Then the Boilers Act will not apply. So these kind of OSH legislations will also not be applicable. So whether we take the area of, IR, I said the 3 acts will not apply, and wages, they say minimum wages will have to be paid, but it doesn't say the entire Minimum Wages Act has to be respected. It only just says the minimum wages notified by the Uttar Pradesh government have to be paid, which means that again, that workers cannot demand fair wages, let alone living wages. They cannot even demand fair wages. All the laws in the 5 areas, that is, the 5 areas are laws relating to wages, laws relating to industrial relations, laws relating to occupational safety and health, laws relating to working conditions, and laws relating to social security. It also means that laws relating to social security, such as the Employees Provident Fund Act, the Employees State Insurance Act, the Payment of Gratuity Act, they will not apply. So you can imagine how the situation will be if none of these laws were to be applicable to factories and manufacturing establishments for a period of 3 years. It means for a period of 3 years, workers will not have any freedom of association and collective bargaining rights. They cannot form and join trade unions. They cannot register trade unions. They cannot demand recognition of their trade unions. They cannot enter into negotiations with employers in respect of the wages and other conditions of work. Then it also means workers will not be entitled to any annual leave for a period of 3 years. They cannot claim any bonus. Then they will have no protection against unlawful termination, because if the Industrial Disputes Act goes, which means even permanent workers can be thrown out of employment overnight without any compensation. And then if the Contract Labor Act goes, what it means that the management is free to engage, employers are free to engage contract labor for any kind of work, including work of a permanent and perennial nature. They can engage contract labor for regular production work. So one implication is also, the ordinance thankfully has still not been assented to by the president. So the government is only in the process of promulgating the ordinance, but assuming that the ordinance were to be promulgated, then this would be the scenario. Workers would be deprived of freedom of association, collective bargaining rights. They will not have fair wages. They will not even have basic amenities like drinking water, toilet facility, because the employer is not obliged to provide that. I mean, they may have it, but they cannot demand it as of right. They can't even demand these basic amenities. They may not have basic amenities like canteens, creches for the children and so on, because all these provisions, they come within the health and welfare provisions under the Factories Act, which are not going to be applicable for a period of 3 years. And plus, workers will not be entitled to social security. And if laws like the Contract Labor Act do not apply, it means that the logical consequence of that is that the employers can operate with an entirely precarious workforce. They can throw out all the permanent workers in the factory overnight without paying them any compensation and run the factory with an entirely precarious workforce. So if this ordinance were to be promulgated, if it were to become a law, it will obviously not stand the scrutiny of law, because it violates fundamental rights. It definitely violates Article 21, this ordinance, which is proposed to be promulgated. Then it also violates various international labor standards that India is a party to. It's the Hours of Work Convention again will be violated. Though UP has rescinded one notification extending the hours of work to 12 hours, this ordinance also regulates the hours of work by extending the hours of work to 11 hours. So it's just 1 hour short. So again, the Hours of Work Convention will be violated. Then the Maximum Weight Convention will be violated. Then Occupational Safety and Health Conventions like the Benzene Convention will be violated. The Labor Inspection Convention will be violated. And so this again can't stand with the scrutiny of law. Now, Madhya Pradesh, it has not gone as far as Uttar Pradesh, but in Madhya Pradesh, what has happened is new industries have been exempted from the provisions of the Industrial Disputes Act for a period of, I think, 3 months. New industries have been exempted from the provisions of the Industrial Disputes Act, except those relating to layoff, retrenchment, and closure. But if they are exempted from the other provisions of the Industrial Disputes Act, again, it means that they will not have any protection against acts of anti-union discrimination. They will not have any protection against acts of interference. Broadly, in India, these acts of anti-union discrimination and acts of interference are described as unfair labor practices under the Industrial Disputes Act. So in MP, they will not have any protection against unfair labor practices, which in effect means they cannot exercise their freedom of association, effectively exercise their freedom of association rights. Now, collective bargaining again gets affected because of the Industrial Disputes Act, which recognizes the right to collective bargaining and which gives sanctity to collective bargaining agreements entered into by trade unions with employers. So if all the other provisions of the Industrial Disputes Act will not apply, it also means that workers in effect will not have any collective bargaining rights. So this again is, this doesn't bode well for workers. Now, the third kind of labor law change which has been made is increase in the numbers threshold for the applicability of laws. This has happened in Tripura. In Tripura, the numbers threshold for the application of the Factories Act, it has been raised from 10 to 20 in the case of factories operating with electric power, and from 20 to 40 in the case of factories operating without the aid of electric power. Now, such changes have also been effected earlier in some states. Rajasthan was the first one to make such a change of increase of numbers under the Factories Act. In Rajasthan did this as far back as in 2014. And then Maharashtra has made such a change. Andhra Pradesh also, I think, has made such a change. So Tripura is not the first state to do so. But I was just pointing out that this is one of the labor law changes made in the post-lockdown period. Tripura has made this very recently in the wake of the COVID-19 crisis and the prolonged lockdown. Now, the fourth kind of labor law change that has happened in the very recent past is exemption from labor inspection. Now, for very long, for the last 6 years, the central government has been whittling labor inspection in various ways. Under the business reform action plans, they have said only red category units should be inspected regularly. Orange category need not have regular exemption. Green category need not have exemption at all. Then they have allowed self-certification in the case of small industry, in the case of MSMEs and startup industries. So this inspection process was already whittled down. And now in the state of Goa, Goa has proposed to permit self-certification, both under the Factories Act and under the Boilers Act. They want to have self-certification. In the state of Madhya Pradesh, the regular system of inspection is going to be substituted by third-party inspection, third-party certification in the case of non-hazardous industries employing below 50 workers. So this again will have a bearing on the occupational safety and health rights of workers. So again, going back to where I began, broadly the four kinds of labor law changes are extension of the hours of work, exemption from labor laws, and increase in the numbers threshold for the applicability of laws, and exemption from labor inspection. And none of
Last
these
2 minutes, ma'am.
kinds of changes. Sorry, Rahul, what did you say?
Last 2 minutes.
2 minutes. Okay, then I'll just like to speak a bit about the way forward. Let me not focus on the changes anymore. Now, I have a few suggestions on the way forward, how the economy could be revived. So my first suggestion would be that all the law and policy responses should be based on gender inclusive social dialogue. There should be social dialogue with workers, representatives of all kinds of workers, both representing workers in the urban economy and rural economy, and all sectors of workers. The specificities of workers in all sectors should be taken into account. And when I say gender inclusive social dialogue, I mean not only women, but also transgenders, because transgender workers have also been impacted by the COVID-19 crisis and the prolonged lockdown. Secondly, all the law and policy responses should be equitable and sustainable. They should take into account the rights and interests of all workers. And then fourthly, I would like to say there is an urgent need for a few things. One is basic livelihood security for all workers. Then more employment opportunities should be created in rural areas, particularly in view of the reverse migration that has taken place now. Then Manrega should be made more robust. And we need something like Manrega in urban areas too. And Himachal Pradesh has shown the way. Himachal Pradesh in the recent past has brought out a Manrega-like scheme which will apply to urban areas. So that needs to be looked into. Then the coverage of social security schemes should be extended to cover all workers. Then there should be universal coverage of laws for all persons in the world of work. Then an employment policy should be framed providing for full and productive employment for all workers. Then we need to have a policy relating to migration. Again, there is a vacuum in that area. And obviously that policy also should look at reducing the push factors for distress migration. Then all the orders and notifications raising the hours of work to 12 hours should be rescinded immediately. Occupational safety and health standards should be respected. Then all international labor standards should be respected. And lastly, I would like to say that labor administration and labor governance systems should also be strengthened and made more robust to ensure strict implementation of all the labor laws to protect the interests of the workers. Thank you.
Thanks, Advocate Ramapriya Gopalakrishnan. Now, I would like to call upon my colleague, Dr. Rahul Sapkal, to pose some of the questions and moderate the session. Please, Rahul.
Yeah, thank you all the panelists for accepting our invitations and giving your thoughts, your recent work, and also sharing your experiences with the discourse on labor in India, and more notably that what the labor law changes has happened, how the world of work is changing in the post-COVID world, for highlighting some of the gaps. I know that we do not have answers to all the questions, and due to the limited time that we cannot discuss each and everything, but in the subsequent discussion webinars we would like to take up some of the points, and then we would like to address it in the future. So there are total more than 80 questions have come, but due to the paucity of the time, and we could see that okay, the number of participants are also started falling down. So we have selected two questions for each speaker, and then each speaker will have three minutes to respond. I know that we could not cover, so this is on behalf of the team. I would like to apologize that we could not cover the entire questions over here, but that will be shared with all the panelist members, and their email IDs are with you. You can write to them, you can personally chat with them. So like the first question, I'll go with the order. The first two questions are for the Professor Shyam Sundar, where some of the participants have asked two questions. What are the repercussions would the codification of a labor law will bring towards the micro and state level, fostering the social dialogue, where the rights, the foundation of a rights itself is been eroded. The second question is about because these post-COVID world, or maybe the post-COVID challenges would be to ensure the living security of every worker. In that case, shall we rethink comprehensively about the new discourse on the labor laws? Or to Sabina, there are two questions. Coexistence of a labor shortage and unemployment is actually increasing due to like a pandemic and the ensuing lockdown. Then how this crisis could be resolved? Means how this coexistence or the contradiction could be resolved. The second question is how could the labor and how could the labor absorption could take place when the labor laws is actual labor and the labor standards, when Amit Basole, there are two interesting questions as in the labor and capital, and it is going to be intensified in the post-COVID time. So in this case, what would be the future of Indian worker when this contradiction is going to intensify? Do you see the law as an instrument where that contradiction could be minimized, or do you see that we should completely go with the self-reliance and the self-enforced laws instead of relying on the constitution to impose the laws? So what is your opinion on this? The second question is, you are rightly pointing out about like we have a MGNREGA in the rural side, but we also needs to see the viability of the employment guarantee in the urban areas. So here the question comes, when you have these employment protections or the employment guarantee schemes, how they are viable in the long term, in the long term, in terms of addressing these questions, because the ensuing crisis is going to haunt the Indian economy for the years to come. To Advocate Ramapriya Gopalakrishnan, two questions has been raised by the participants. What is the legal standing of these proposed changes in the Supreme Court? Because many trade unions are now filing petitions into the various high courts as well as Supreme Court, because these changes have been made under the pretext about the COVID-19, and the crisis has been given, as a context where these changes have been brought. And the last question is about the future of labor laws. What do you think as a practitioner lawyer? What is the future of a labor laws in the post like a COVID-19 times? Yeah, thank you. Please, each speaker will have a 3 minutes. Thank you. We can go in order.
Maybe we can start with Professor Amit and then.
Okay, yeah, sure. I'll be brief. On the two questions, both very good questions. On the role of law, so as you would have guessed, I'm an economist who is wading into all kinds of tricky waters when we talk about labor laws, and I realized that there are many things that I don't actually understand about how, let me say, how legislative frameworks interact with economic conditions. Broadly, that's what we're talking about here. So my very initial thoughts on this would be that the constitutional framework as well as the other legal framework is absolutely necessary. And of course, as I mentioned, in the context of a surplus labor economy, it is incumbent on the state to protect the interests of labor because the market does not protect it. That's a very simple fact of labor surplus economies. Going even beyond the standard capital labor contradiction. So absolutely law has a central role to play. What I was trying to say was that this is a necessary but not sufficient condition. Obviously, the legal framework is necessary, but it is not going to be sufficient because in the presence of very slack or very loose labor markets, the cost of enforcing that regulation increases. That's one way to look at it, right? How costly is it to implement those laws? That cost is going to increase the slacker the labor market, because the stronger the forces of the market against which you have to implement those laws. Hence the need to work on both those sides, that you have to tighten the labor market in order to make your life easier to implement the laws that you want to implement. That's what I'll say about that. On the question of the employment guarantee and the viability, so I'm glad that the example of Himachal was mentioned. The other state that has had an employment guarantee program in urban areas for a few years is Kerala. It's called the Ayangali Urban Employment Guarantee Scheme, very similar to Narega. Of course, Kerala is an exceptional state, so not too many states can probably draw lessons from it necessarily, but it's there in Kerala. It has been announced by Himachal. It has been announced by Odisha. Neither the Odisha nor the Himachal programs are laws. They are not acts. They are simply schemes, and they are very, very underfunded for the purpose, but they're nevertheless important baby steps in the area of urban employment guarantee. The big program can only come nationally because it's very costly. That goes to the question as to how viable is it in the long run. Now, the first thing to say about an employment guarantee program is that you expect that over time that program should become redundant, meaning you should not need it. If you continue to need it in large numbers, it means that the private economy is not working properly. So obviously, we don't want these programs to be a stable feature of the Indian economy. We want them to be protection nets for those who do not find a place in the private economy. Now, can the government afford such a program now? And can it afford it for years to come if COVID is going to have long-term effects? So my answer to both those questions is yes, because the way we have thought about the program, it creates substantial assets which are going to have spillover productivity effects and so forth. So this is not simply a public works program that boosts demand by paying people, right? It is a program that actually provides for important public goods and services that are needed in towns, which will pay us back in terms of economic growth. So the viability aspect has to be seen in that context, that it's a program that has those spillover effects. But nevertheless, it is going to be an expensive program. I think we should bear the cost of it, even if the debt goes up. This is a separate kind of issue about fiscal deficit and debt that I don't want to get into right now, but I think we can afford it.
Thank you, Amit sir. Now, Advocate Ramapriya, can you just respond to the question quickly?
Yes, I'll do that. So the first question that was asked to me was, what is the legal standing of the labor law changes in the Supreme Court? So I would like to respond by saying that I had already pointed out that the labor law changes relating to extension of hours of work to 12 hours a day and 72 hours a week that will not stand legal scrutiny because it's in violation of the international labor standards contained in Convention number 1 that India is obliged to respect. It's committed to respect the principles contained in Convention number 1. And plus, this is also is in violation of the right to health and right to just and human conditions of work, which have been held to be the part of the right to life protected under Article 21 of the Constitution. So it cannot stand legal scrutiny. Similarly, the exemption from labor laws, there's no way that can stand legal scrutiny in a court of law, because that is the implications of that are violation of Article 19(1)(c), which protects the freedom of association of workers. Then again, if all labor laws do not apply, again, it means that workers will not have just and human conditions of work, and their right to health will be compromised. And this again would amount to a violation of the fundamental right to life protected under Article 21 of the Constitution of India. So these legal changes cannot stand the scrutiny of law. They are in violation of international labor standards, as well as they are in violation of the fundamental rights protected by the Constitution of India. The second question posed to me was about the future of labor laws. And here I would like to say that labor laws are as relevant today as they are in the pre-COVID and pre-lockdown days. So the labor laws will have to apply as it is. They cannot be diluted, they cannot be undermined, they cannot be whittled away. Labor rights are human rights. These laws protect basic standards. And if at all, if there any temporary exception needs to be made, it can be made only after social dialogue and with mutual consent, meaning the government cannot unilaterally make changes and impose it on the workers. Workers will have to agree to such changes if at all any changes need to be made. If at all any temporary exemption needs to be made, even for a brief period of time, it will have to be made only if workers' organizations explicitly agree to it. It cannot be done unilaterally by the government. So once again, I would like to say labor rights are human rights and need to be protected. Rahul?
Rahul?
Yeah, thank you. Yes. Can we go now to Miss Sabina?
So the question to me was about the coexistence of the labor shortage on the one hand and rising unemployment on the other, and how those two can coexist and how they can be addressed. I think that, and this is my view, that the labor shortage right now is temporary, and it's more about if we're talking about sort of migrant workers, latest estimates show about 5 million workers that are kind of heading back to their hometowns. And so the labor shortage, in terms of migrant workers, is about 5 million. There may be a number of other workers that are still unwilling out of fear of contracting the infection, that might be sort of unwilling to work. But I believe that once things start to open up and once the pandemic starts to come under control, that this kind of labor shortage will start to subside. That, of course, raises the question, which I tried to allude to, but maybe didn't bring up very clearly, about, it's not just a pull factor of rural areas for these migrant workers, it's also a push factor. Gautam Ban from IIHS wrote what I thought was an excellent op-ed talking about the vulnerable conditions that a lot of these workers live in urban areas that are actually push factors for sending migrants out. So the idea of labor shortage is in the COVID context, I think is 5 million workers, which, we have to put it in context of 500 million labor force. With regards to, I think, a longer term horizon, of course, there's huge mismatches in terms of the skills and education of workers, in terms of their geographic locations and what the demand is. And those I cannot address in 3 minutes. I think that we need to have a longer conversation about how do we sort of match and do this labor matching between companies and existing demand and workers. So that's the labor shortage issue. I think fundamentally unemployment in the past, if you looked at the range of people that were unemployed, they had higher levels of education, which in a way is a proxy for higher levels of income. And now we're seeing sort of more segments that are, unemployed. And I think this is something we have to watch, but what it points to is a fundamental lack of demand in the economy. And some of that demand has to come from removing barriers to establishing new businesses and growing new businesses. But the other part of it also has to come from demand through, giving people money to spend so that they can buy products, and creating this virtuous circle that actually facilitates more business activity. So I think I'll leave it at that. I mean, I think that the labor shortage is temporary. I think the demand side is hugely important, but the demand side connects back with the supply side when we start talking about, people actually spending money and having decent wages and regulatory protections, and, being able to participate economically and realize their productive potential in order to actually spur aggregate demand. So we have to think about both of these together. Thank you.
Thank you, Sabina, for responding to the questions raised by the participant. So here, I just like to, in few minutes, I'll just summarize the discussions. The COVID-19 crisis has actually gave a lot of challenges to the workers, and it is really asking a serious questions about the governance issues and the rights-based issues. And it is also creating a lot of serious challenge, the kind of development discourse we are going to see or we are going to witness. And instead of actually giving answers based upon our experiences, we are posing a new questions, and these new questions will unfold as we move ahead. So on behalf of the CRC, Working Solidarity Network, and School of Management and Labor Study of TIS, I really like to thank all the participants, both from India and abroad, who managed to come here and actually spend a couple of hours with our panelists, listening to their views, their perceptions. And I would like to thank all the panel members. I know that despite their busy schedules, they managed to spend some time with us and to share their recent work, their opinion with us. And hopefully that we will carry forward these discussions. Like some of the questions we could not address, but we will carry forward this discussion in the future rounds of discussions where we are. So I would like to thank we will share the recordings as well as the questions through personally to all the participants who have registered with us. You can also follow all the trends into the Facebook Live and the Twitter. Thank you very much. Dheeraj, it's over to you.
Thanks, everyone. We can close the webinar. Yeah. Look forward to the next one. Yeah. Thanks.
Thank you, everyone.